Elena's car gets hit on Hempstead Turnpike. She's shaken. She's hurt. She calls her insurance. 3 hours later, the other driver's insurance calls her. They're friendly. They're sorry this happened. They just need to ask a few quick questions. Elena answers. She has no idea. She just handed them everything they needed to kill her claim. 7 specific moves insurance companies run on accident victims in New York. I've spent 30 years watching every single one. We're counting them down from bad to devastating. And the number one trick, it's the one that works on almost everyone, including people who think they know better. We're getting there. 30 years fighting insurance companies in New York. Same playbook, thousands of cases. Let me show you all 7 moves. Number 7, surveillance. After you file a claim for serious injuries, there's a real chance someone is watching you. Not a metaphor, an actual investigator hired by the insurance company, photographing you at the grocery store, recording you at your kid's birthday party, following you to your car. You claim a herniated disc. They catch you carrying bags. They catch you walking across a parking lot without a visible limp. They're not going to tell you that's normal for people in pain. They're going to build a narrative. The claimant was observed engaging in physical activity inconsistent with the injuries described. That's what they're going to say. Does this mean you should fake your injuries? No. It means you should know this is happening. And it connects directly to number 6. Number 6, social media monitoring. Surveillance used to mean a guy in a parked car. Now, it's your Instagram, your Facebook, your TikTok, any photo of you looking happy, active, outdoors at a wedding or a family barbecue gets screenshotted and attached to a file. A photo of you smiling at a birthday party 3 weeks after a back injury doesn't prove you're not in pain. But in the hands of an insurance adjuster, building a story, it becomes, quote, the claimant appeared in good spirits, engaging in normal social activity, showing no signs of the injury claimed. You say, Richard, come on. I'm supposed to go into hiding? I didn't do anything wrong. I hear that. And you're right. But what you put online is one of the fastest ways insurance companies reduce your recovery. Lock down your profiles. Stop posting. Tell your family not to tag you. Anything visual is evidence. So far, numbers 7 and 6 are about building a picture of you that contradicts your own claim. Number 5, the IME Doctor. Independent medical examination. The word independent is doing a lot of work in that phrase. Under New York no-fault law, the insurance company can require you to submit to a medical examination. You generally have to go. What they don't tell you, that doctor is hired and paid by the insurance company. Their finding in the overwhelming majority of New York personal injury cases supports the insurance company's position. Your injuries are less severe than you claimed. You've recovered. The crash didn't cause them. I've had clients walk in with documented herniated discs and walk out with an IME report that reads like they had a minor sprain. That report goes in the file. It'll be used against you at mediation or in a deposition or in court. Document everything before you go. Keep treating consistently. Never let a one-time insurance-paid examination become the defining medical record in your case. Now, we're going to loop into the top 4. This is where the real damage happens. Number 4, the lowball offer. After they've collected their evidence, they make an offer. It'll be low, sometimes insultingly low. The goal is to see if you're desperate or uninformed enough to take it. The first offer is almost never the real number. To know whether an offer is fair, you need to know what a case is actually worth. That means understanding your medical costs, your lost wages, your pain and suffering under New York law, and comparable verdicts. The adjuster knows all of those numbers. They're betting you don't. You say, Richard, what if the offer seems reasonable? What if it covers my bills? Listen, if it covers what you've already spent, but nothing from the future, no future treatment, no long-term impact on your life, it's not a fair offer. It's a low one dressed to look reasonable. Get a lawyer to evaluate any offer before you respond. Every time. Number 3, the quick settlement offer. This one comes before number 4, sometimes the same week as the crash. They'll call, they're sympathetic, they want to take care of this quickly, and they have a check ready right now. Here's what they know that you don't yet. Soft tissue injuries, neck, back, shoulder, often don't develop fully until 24 to 72 hours after impact, sometimes longer. They want to close the file before the full damage picture exists, before you've seen a specialist, before the imaging results come back, before the surgery bills arrive 6 months from now. Once you sign a release, that case is over. There's no more coming back for more, where the real extent of your injuries becomes clear down the road. Quick settlement offers are designed to meet you at your most vulnerable before you've consulted anyone, before you know what you're dealing with. Sign late. Sign with a lawyer. Never sign the week of the crash. Number 2, exploiting gaps in treatment. This one is subtle. That's why it works so well. You were hurt. You treated for a few weeks. Then you missed some appointments. You were hoping it would get better on its own. You had trouble getting in to see your specialist. Life kept moving. Weeks went by, maybe months. The insurance company will argue those gaps mean you weren't really injured. If the pain had been as severe as you claimed, you would have kept treating. That gap becomes their narrative, and a narrative is exactly what they need to reduce your recovery. It doesn't matter that you had trouble getting an appointment. It doesn't matter that you were trying to get back to work. What matters is what's in the medical record, and gaps in the medical record are evidence. They're evidence. If you were hurt, treat consistently. Keep every appointment. Document every symptom. If you have to stop for a legitimate reason, tell your doctor and get it in the chart. The medical record is the backbone of your case. Leave gaps and you've handed them a weapon. Number 1, the one that works on almost everyone, the one that happens before any of the others, the one I see destroy cases every week, the recorded statement. The first call, same day as the crash, sometimes within hours. The adjuster is friendly, sympathetic. They just need to get your statement on the record. You think, I didn't do anything wrong. I have nothing to hide. Why wouldn't I cooperate? Here's the problem. You've just been in a crash. You're still in shock. Your adrenaline is still running. You don't yet know the full extent of your injuries because soft tissue damage doesn't peak until 2 or 3 days after impact. You say, I'm okay, a little sore. You say you're not sure exactly how fast the other car was going. You try to be accurate and helpful. That tape exists forever. They will use your own words to argue you weren't seriously hurt. They'll use your uncertainty about speed to question liability. They'll take the most favorable moments for their side and replay them at mediation, in a deposition, in court. Your honest, good faith attempt to cooperate becomes their best piece of evidence. You have zero obligation to give a recorded statement to the other driver's insurance company. None. This is the thing they'll never tell you. They call like it's routine, like it's required. It's not. Do not give a recorded statement without speaking to a lawyer first. Full stop. That call is the foundation of their case against you, and most people answer it without ever knowing what it becomes. 7 tricks, same playbook, 30 years, thousands of cases. The recorded statement is the number 1 because it happens first, and it gives them everything they need to run the other 6. If they've already called you, the earlier we're involved, the more we can protect. Now you know the playbook. If you have a dash cam footage from your crash, go back and watch the first video on what that footage actually proves, and pay attention to what the insurance company is already looking for in it. Now you know why their first call is a recorded statement. I'm Richard Jaffe at Cohen and Jaffe. If an insurance company is already working your case and something feels wrong, our number is in the description. Subscribe. Which of these 7 have you actually seen? Drop it in the comments.